to this morning's Land Use Hearing Officer hearing. My name is Steve Luce, and I'll be conducting this morning's cases. At this point in time, if you could all rise for the Pledge of Allegiance. Pledge of Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. You may be seated. At this point in time, I'd like to introduce Colleen Marshall from Development Services staff, who will introduce the other members of the county staff that are here today and go over any changes to this morning's agenda. Colleen?
Good morning. Colleen Marshall, Development Services. To my left is Mary Dorman and Jared Delfino of the Hillsborough County County Attorney's Office. Carmen Mason of Development Services staff is joining us virtually. And Alexis Myers, the Planning Commission staff, will be presenting virtually. During the course of the hearing, a number of other staff planners will be presenting their findings for various cases and will be introduced for each item. We have no changes to the published agenda.
All right, very good. I have a few instructions to read into the record. The County Attorney's Office staff has a few instructions to read into the record, and then we'll get started. It'll only take a few minutes. Our hearing today consists of agenda items that require a public hearing by the Land Use Hearing Officer. I'll conduct a hearing on each agenda item and will file a decision within 15 working days at the conclusion of today's hearing. Our hearing will be informal. I will ask questions related to the scope of direct testimony. I may call and question witnesses as I deem appropriate, and I will decide all questions of procedure. I will take evidence, but will exclude evidence that is irrelevant, immaterial, or unduly repetitious. Evidence may be presented in written form, and all testimony must be under oath. Hearsay evidence may be used to supplement or explain other evidence, but shall not be sufficient alone to support a finding by me unless it would be admissible over objections in a civil action. Regarding the order of presentations this morning, regarding the variances, Development Services staff presents their staff report and findings, and they have 5 minutes for that purpose. Then the applicant presents their case, and they have 15 minutes for that purpose. Then anyone in the audience who wishes to speak in support, there's a total of 15 minutes for those people who want to speak in support. Then there's an opportunity for those who are here to speak in opposition to speak. There's a total of 15 minutes for that purpose. Then Development Services will have an opportunity to address any comments heard. And finally, the applicant will have an opportunity for rebuttal, and they have 5 minutes for that purpose. There's one special use on the agenda, and I will talk about the process and procedures for special uses when that item comes up. It's the last item on this morning's agenda. Regarding the time for opponents and proponents, 15-minute time frame is the total time for each category. If there are a number of people to speak, we'll add up the total number of people, and the 15 minutes will be divided as equally as possible. You may wish to designate a single spokesperson to more efficiently use the time. When you come up to the podium to speak, please start by giving your name and address for the record. There's a sign-in sheet down at the end of the podium, and if the clerks can raise their hand and point to where the sign-in sheet is. Yeah, there we go. The meeting is being recorded, and we want to make sure we accurately document who is speaking on the record. When you are done speaking, please sign in with the clerk's office with your name, address, and application number of the agenda item you're speaking to. At this point in time, the County Attorney's Office will now provide the legal requirements for appealing a decision made by the Land Use Hearing Officer.
Good morning, Jared Delfino, Assistant County Attorney. This Land Use Hearing Officer public hearing is for variance and special use requests. This is the time for interested parties to present evidence and testimony. Once the Land Use Hearing Officer has closed a case, the record of that case is also closed, and no new evidence regarding that case may be submitted thereafter. Any decision by the Land Use Hearing Officer may be appealed to the Land Use Appeals Board. Should a decision of the Land Use Hearing Officer be appealed, the record evidence, including the testimony presented at this public hearing, shall be the only evidence that is subject to review by the Land Use Appeals Board. In reaching a final decision on petitions, the Land Use Appeals Board will only consider the decision of the land use hearing officer and the record evidence, including any evidence from this public hearing. If an appeal is filed, the Land Use Appeals Board hearing shall consist of oral argument by the party appealing the decision, county staff, and any interveners, each of whom may be represented by legal counsel. The following shall have standing to appeal a decision of the land use hearing officer or to intervene in an appeal. 1, the applicant, or 2, anyone who appeared before the land use hearing officer, presented testimony or other evidence, and is adversely affected by the decision of the land use hearing officer. It is the role of the county attorney's office to ensure that no new evidence or testimony is allowed before the Land Use Appeals Board that was not presented to the land use hearing officer at today's hearing. The county attorney will recommend that the Land Use Appeals Board disregard evidence or testimony that is outside the record made at today's public hearing. Any evidence presented to the Land Use Appeals Board that is outside the record created at today's hearing could jeopardize the legality of the Land Use Appeals Board decision, and the presenter of that evidence could hurt their own cause. The safest course of action, then, is for you to write down any comments you make today and repeat them to the Land Use Appeals Board. Thank you.
Okay, thank you. All testimony must be provided under oath this morning. Therefore, if you plan to speak, please stand and raise your right hand so I may swear you in. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, thank you. You may be seated. And regarding cell phones, make sure they're all on silent. Okay, at this point in time, Ms. Colleen Marshall, if you could introduce the first item for this morning's hearing.
Today's agenda, we have no vested rights, fee waivers, remands, reconsideration requests, or site development variance requests, which brings us to Section G, signed variance requests. Item G1, variance 26-1004. The applicant is David M. Smith. The request is a variance to sign requirements. Staff findings will be presented by Sam Ball.
Okay. Sam? Good morning.
Good morning. Sam Ball of Hillsborough County Development Services. The applicant is requesting a variance to increase the allowable building sign area on a new building constructed at the southwest corner of the Selman Expressway and South US 301 intersection. Under LDC Section 7030A2, the maximum sign area allowed on the north elevation is 200 square feet. The applicant is requesting a 301 square foot increase to the maximum permitted area, which would allow a 501 square foot wall sign on the north elevation. That concludes my report if you have any questions.
No questions, thank you.
Thank you.
The applicant, please. Morning.
Good morning. David Smith, Director of Development and Zoning for Stearns Weaver Miller on behalf of the applicant. As Sam indicated, this is a variance request to increase a building sign from the allowed 200 square feet to 501 square feet. The factors contributing to the reason we're asking for this variance: the elevated and curved roadway of the Selman Expressway, existing vegetation obstructions as you're approaching the exit ramp, extraordinary setback conditions that exist because of wetlands on site and the building setback in the way that the right-of-way is angled for the Selman. And the scale of the building and proportionality results in a smaller sign basically being lost on the facade. Here's an aerial map of the project. This is approximately a little under 800,000 square foot warehouse. It's phase one of 1.4 million square feet going on the site. The sign location would be on the north facade. We also have approval for commercial at the corner of 301 and Causeway. And then there's a facility included in this, which is also the fleet maintenance facility for the project. This indicates the location of the proposed wall sign. Again, it's at the extreme northeast corner of the building, and it parallels the Crosstown Expressway exit ramp. So the practical difficulties that we're experiencing here is essentially unique and singular due to its location abutted on the north by the elevated Selman, the east by 301, and the west by Delaney Creek, and the south by commercial portion of a mixed-use intersection of US 301 Causeway Boulevard. Location characteristics, elevated settlement and off-site wetland along Delaney Creek contributing to making the property unique and singular. The LDC provides for building signage for each premise, and for multi-purpose tenant buildings, each unit based upon 1.25 square feet for every square foot, not to exceed 200. In our particular case, a 200 square foot sign is what we're asking for the variance from, given the criteria or given the situation out there that we're experiencing. A 200 square foot sign essentially becomes illegible and lost amongst all those obstructions. There's about a 900 long facade for this building. It's quite a large building. And this would be the only building sign on that side of the building. So how would the variance allow not substantially interfere with or injure the rights of others? Given the location of the building sign location proposed at the northeast corner of its facade, no adjacent properties will be negatively affected. The proposed sign is located at least 1,000 feet from the nearest residential property, which is located northwest of the proposed sign and has its view obstructed by existing off-site vegetation. To the north of the elevated settlement expressway and commercial development on the north side of the expressway, and to the south is property that is part of the same mixed-use project, with no view of the sign location. And to the east, the sign can only be seen from the intersection of 301 and the settlement exit ramp. The request is in harmony with the code because essentially the LDC is, and the intent in the development process is to protect the rights of property owners in consideration of interests of the citizens. Given the scale of the development and physical constraints and the limited visibility and legibility of the proposed code compliance sign, approval of the variance is in harmony with the owner's rights and the interests of the citizens of Hillsborough County. It will not result in getting to the actual sign purpose. The purpose of sign regulation to provide minimal control of signs necessary to promote health, safety, and general welfare of the citizens, lessen hazards to vehicular traffic, preserve property values, preventing unsightly and detrimental signs, and essentially preventing there having just signs everywhere. The variance does not result in an illegal act of the applicant. We're here asking for the variance to receive relief based upon the obstructions and unique situations that we've experienced with this site. And its substantial justice will be allowed granting this variance. And since the variance for the larger building sign provides clear identification of the business on the subject site, which enhances public safety, will not be detrimental surrounding property owners, and will not have detrimental impacts on the sign code as it was adopted, the purposes that it was designed to protect. So what's missing here? Great. Somehow we did not scan, and I'll put them on the Elmo if I could. This is essentially the sign and the location on the proposed building. This is kind of a viewpoint map. So what I'll be showing you over the next few slides is views from the settlement towards the building where the sign will be located on site. Here, as we're heading eastbound on the settlement, you can see in the foreground a red corner of the building. That's approximately 900 feet with no sign shown. That shows the same distance with a 200 square foot sign shown on the building. Very hard to see. And I'll have to admit, at 900 feet, it's hard to see them regardless. But at 900 feet, the larger sign, you can make out the sign. You know as you're coming down that ramp, okay, hey, there's the Coca-Cola building. Similarly, we have, when you're getting closer and you're getting on the ramp, the other was at the beginning of the exit ramp. There's no sign. 200 square foot sign. There's a 500 square foot sign from the building. And again, relationship-wise, very large setback between the edge of the Selman and the building. And at this point, we've passed by the cypress trees that are in Delaney Creek obstructing the view. Again, eastbound, we're on closer down the ramp now. We're about 700 feet away with a 200-foot sign, and it's a 500-foot sign. So looking, the only other place it could be seen, this is at the intersection of 301 and the exit ramp intersection, and that is on the east side of the building. That's no sign. It's a 200 square foot sign, and that is the 500 square foot sign. So essentially, get the general idea is that, you know, given the scale of the building, given the obstructions, the Selman is also elevated. At this point, you actually, as you exit, you go up, and then you go down to 301. And when you're coming, I'll just give you a couple other views. When you're coming westbound, until you actually get on top of the overpass, you can't see the sign at all. But I'll just give you two perspectives. That would be a 200 square foot sign, and that would be a 500 square foot sign on the building. So based upon those graphics and illustrations, it represents the obstructions that we're running into, and I've gone through the waiver criteria, and apologize for a little inconvenience when those signs, those aerials didn't get put in the presentation for some reason. Okay. Here to answer any questions. Respectfully request your approval.
All right, very good. Thank you. No questions.
Thank you.
At this point in time, is there anyone in the audience who wishes to speak in support of the application? Is no one responding? Anyone in the audience wish to speak in opposition to the application? Is no one responding? Staff, anything further?
Nothing further. Thank you.
Applicant, an opportunity for rebuttal? Okay, no need for rebuttal. With that concludes this application. Ms. Marshall, we're ready for the next item.
Next, this brings us to Section H, variance request. Item H1, variance 260884. The applicant is Maria Concepcion. The request is a variance to accessory structure requirements. Staff findings will be provided by Logan McCaig.
Okay. Good morning.
Morning. Logan McCaig, Development Services, variance 260884. The applicant is requesting a variance to accessory structure requirements for the purpose of constructing an accessory structure in the front yard to store a recreational vehicle. For sections 61104 and 60101, accessory structures shall not be erected within a front yard unless they are at twice the depth of the required front yard or 50 feet, whichever is less. The front setback for the RSC6 zoning district is 25 feet. Therefore, a 50-foot setback is required for such an accessory structure. The applicant is requesting a 25-foot variance to this 50-foot requirement, resulting in a 25-foot setback, and available for any questions.
No questions, thank you. And the applicant, please. Morning.
Good morning, sir. My name is Maria Concepcion. My address is 2509 West High Avenue, Tampa, Florida 33614.
Okay.
We currently own an Integra RV.
Could you please grab the microphone?
We currently own an Integra RV or mobile home or recreational vehicle, more well known. It is a 41 feet Integra 2023 Riata XL. This is a picture that represents a similar model. With the current application done, the setback requested was 50 feet. We understand that 50 feet would be double what is required for a regular construction. With our new proposal, we are requesting to, instead of having a 50-foot setback, having the 25-foot setback that falls within the same category that every construction has in this area. I have a picture. So this is a aerial vision from the property's appraisers. So the blue line represents the law lines where constructions typically start in this neighborhood. This is our property. Currently, this shed no longer exists. It was a covered carport that we removed, where we are proposing to install this new shed. The proposal requires a diminished setback because, as you can see here in our survey, there is already a garage that is built in this area. If we are to adhere to the 50-foot setback, we would be left with a shed of approximately 18 feet, which wouldn't cover half of our vehicle. And seeing as is such an expensive purchase, we're looking to protect our assets. So we're we're requesting to shorten the setback to the 25-foot for every single construction that is in this area. The proposed shed has been applied for a 18 by 44, but we would be reducing it to a 40-foot to adhere to that 20-feet setback.
Okay. Does that conclude your comments? I have a few questions.
Okay,
All right. There's an existing garage which you had on the graphic?
correct.
Could you pull
Yes,
that
sir.
back up again?
Yes, sir. This is the survey.
Right.
This is the garage that is existing.
Okay, and did you look into putting the new garage in the location of the existing garage?
So the shed will be located in front of the garage. As it is applied currently, it looks as such.
Okay, the question is, why not demo the existing garage and push your new proposed RV garage back further?
Because we would have to limit our storage space on a single-family home that is currently habited, and it's being used for storage.
It's currently what? Sorry?
There's a family living in this current house, and they are using the garage as storage because the storage inside the home is limited.
Okay, so you don't live in this house?
No, sir.
Okay. And so, okay, wherever you live, you don't have any room on your lot for your RV?
No, sir. The RV is being kept in one of our commercial properties where we are now requiring the space for enlarging our building. Not enlarging our building, but our storage facilities.
Say the garage is being utilized for storage by the renters.
Yes, sir.
What if that renter moves out, like next week?
It's not a renter, it's a family member that is living in this property.
Okay, what if the family member moves out? They don't own it. What if they decide to move out? We don't, for some reason, we're going to move somewhere else. Then there's no storage there.
In that
It's a
case,
temporary, point is, it's a temporary situation.
the storage in the garage currently is temporary as they are living in the property. The RV would be permanently located, stored there.
Yeah, you're missing my point. If your tenant, family members moves out, then there's no longer tenant, family member storage in the garage. That storage goes with them.
Correct, sir, but the limitations in the house storage remain. So whoever moves into the property might still need the garage for storage.
Well, the purpose of a variance is to show that you've explored all other possible scenarios. What if you built a shed for storage? If the proposed new garage isn't adequate enough for the RV and storage?
Unfortunately, in this part of the property, there can be any constructions, which is where the septic tank and the pipes are laid. So the only storage area would be here, and we are limited regarding the building lot. We also have to respect side setbacks. And as far as I understand, the garage is already limited to this placement. If we were to tear down the garage, we would have to build even closer to the property, to the house.
The septic tank drain field is
Behind the
Yes.
house, sir. Right
south of the garage, or,
here. Right here, sir,
right?
in this
What
area.
about a shed on the other side of the garage?
There is limitations regarding the setback from the side of the property as well, since this is a residential property.
Which is, do you know what the setbacks are, 3 feet?
No,
3.5
sir.
feet?
I'm not familiar, but since this is a double wide lot, the limitations are larger because of the conditions of the lot.
Okay, I'll do my own research, but I don't think that's true. I think their setbacks are probably in the range of 3 to 4 feet.
I'm not aware at this moment.
I also checked, looking at the ownership pattern along the street to see what's out there. Happened to notice that you own 4 of the 6 lots on that street.
Yes, sir.
I noticed that one of the lots doesn't even have a house on it. There are a couple of garages on it.
Correct, sir. That was purchased as is from the same lady that sold us this property. Once her husband passed away, they separated the lot and sold it to us as is. We're looking into how we can join those lots again, but this is a process that requires a lot of time.
And have you considered putting the RV on the lot with just the garages?
I'm sorry?
Have you considered putting the RV on just the lot that has the garages?
They're not long enough to house such a large vehicle.
Understood, but you would have to tear down a garage or build a new one on this lot that's
Correct,
before
sir.
me. You'd have the same exercise on a different lot where you
Yeah.
could meet the setbacks. Did
Yes,
you-
sir.
did
That would
you
incur
consider that
tearing down.
Possibility.
We have considered this, sir. However, we do also use the current garage as storage for other vehicles.
Okay. All right, the garage itself, is it going to be, have walls on all sides and a roof?
They will have walls on the sides and doors on both the front and the back, so we can access the garage that is going to be behind it.
Okay. All right, no further questions. Thank you, ma'am.
Thank you, sir.
At this point in time, is there anyone in the audience that wishes to speak in support of the application? No one responding? Anyone in the audience wish to speak in opposition to the application? No one responding? Staff, anything further?
I'll just note, when the property being zoned RC6, the side yard setback would be 7.5 feet for a primary structure or an accessory structure over 20 feet in height, and 3 feet if it's an accessory structure under 20 feet in height.
Okay. That's the side yard setback. What's the rear setback then for accessory?
The rear is 25 feet if it's over 20 feet in height, and 3 feet if it's under 20
Okay.
feet in height.
All right. Good. All right. Okay, ma'am, and you have an opportunity for rebuttal?
No rebuttal, sir.
All right, very good. Thank you,
I
ma'am.
request your approval.
Okay,
Thank you.
thank you. Okay, with that concludes this application. Ms. Marshall, we're ready for the next item.
Next item is item H2, variance 260885. The applicants are William and Rose Espinal. The request is a variance to accessory dwelling requirements. Staff findings will be provided by Jared Fullen.
Okay.
Good morning, Jared Fallon with Development Services. This application is requesting a variance to accessory dwelling building setbacks for an existing accessory dwelling on a property zoned RSC 6. According to section 6112E, accessory dwellings are required to meet principal building setbacks. And this application is asking for side and rear yard setback variance. For the side yard, the variance is 2.1 feet, which is resulting in a 5.4-foot side yard setback. And then for rear yard, it's asking for a variance of 22 feet for a 3-foot rear yard setback resulting. This accessory dwelling was flagged by code enforcement due to not meeting setbacks, and it was discovered that the previous renovations done to the building did not receive a permit. And then in our research, we could not exactly find the date when this building was constructed, but we could disseminate that at least 2014, we see the building on aerial photographs. We also could not find when the structure was converted to an accessory dwelling.
Okay.
Happy to answer any questions.
Do we know if that accessory dwelling has power, electricity?
I don't know.
Do we know if it has water and sewer?
I'm not aware, no.
Does it have a kitchen?
If it meets the definition of a dwelling, then yes, it should have a kitchen, or it would.
But you don't know if it does or not?
I don't know, yeah, I'm not sure the specifics of the building itself.
Do you know if it has a bathroom?
No, I'm not sure.
And do you know the height of the accessory structure?
I don't. I think it's on the site plan. I cannot read it on
Okay.
what I've printed, so.
All right, I'll look for it.
All right.
Okay, and the reason why it's here today, they were cited by code enforcement,
Correct.
okay, for not meeting the setbacks and unpermitted building alterations. All right, we just don't know when. It maybe had been a storage shed at one point in time, and now
Yeah, that's a possibility, correct.
it's being used for accessory dwelling
Right.
purposes. All right, got it, thank you.
All right, thanks.
All right, and the applicant, please.
Good morning. Yes, hi, good morning. My name is William Espinal. This is my wife.
Rosa Espinal, good morning.
Morning.
We live in 17632 Meadow Bridge Drive, and we're here to present our hearing.
All right, very good.
Yeah, so we basically bought the house in 2015,
2016.
2016, and we bought it as is. And all the surveys that we got, all the records that we've gotten, even from here for the city, it shows that this has been a pre-existing building since the house was built. So I guess it was a shed. It's always been a shed.
That's not true. I've looked at historical aerials. It was not there when you bought the property.
When we bought the property, or
Correct, when you bought the property.
Yeah, it was there when we bought the property.
I'll strike that. It was not there when the house was built in 1986.
Okay, well, okay. So we bought it as is, so when we bought it, everything was, how we found it like that. So, what we're trying to do is we're trying to apply for the variance because, now that it doesn't meet the setbacks. But the building, as far as we know, has always been there. It was already like that. And all that we've done was just to get permits to get it renovated.
So it was already an accessory dwelling unit when you bought the property,
Yes,
okay?
yeah. So basically, when we...
Do you have any evidence that it was?
that was in there?
That somebody was living there or?
Oh, no, we don't know if somebody was living there. We know that the building was there. The building was like that.
Okay, but it wasn't, did it have, I'll ask the same question for you that I asked the staff. Does it have power when you moved in?
Yes.
Yes, it had power, yes.
All right, did it have public water and public sewer?
Yes, it
When
does.
you moved in?
Yes,
It did,
yes.
okay? Did it have a kitchen?
It's got,
Did-
When we remodeled, because
All right, no, but let's talk about when you bought the property. You said it was as is. It was a dwelling unit.
the building,
Did it
the
have a
building itself,
kitchen
yes.
when you bought it? When you went out back, looked at the shed, did it have a kitchen?
no, it doesn't have, it didn't have a kitchen.
It didn't have a kitchen, no.
All right, did it have a bathroom when you bought it?
It did have we renewed the bathroom. It didn't have like a nice bathroom, it just had a toilet there,
Okay,
but that's it.
all right. Okay, so, all right, I'm sorry to interrupt, but I wanted to make sure I understood.
No, it's okay.
All right, go ahead, proceed.
Okay, so basically, I can just show you some pictures so you know.
The issue is too close from the fence,
Yep.
basically. And we would like to, that's the property. We would like to use the property, you know.
Yeah, this is the main reason why we bought the property, because of this accessory dwelling, because we have a large family, we have 3 kids, you know, and we have 3 bedrooms, so we're basically short 1 bedroom. So we were thinking, you know, when we bought this property, hey, we could use it as a, you know, as a
Guest
dwelling.
room or
Yeah, or like
personal room.
when my mom comes over, you know, that's what we thought we were going to use it for, and we didn't know that, you know, it wasn't allowed to be used.
until the other,
Yeah,
until December, basically.
exactly. So-
Okay, so when you bought the property, remind me again, when did you buy it?
2016.
All right, and when did somebody start living in it?
Nobody lives there.
Nobody lived there.
Nobody lives there.
We just set up like a nice room.
Yeah, there's nobody currently living there. There's nobody living there.
Okay, so if nobody lived there, then how did code enforcement get involved?
We have a disgruntled neighbor that wants to give us a hard time,
So that's why we're here.
and that's why we're here, yeah.
Give you a
So,
hard time about what?
everything.
Yes, it's,
Yeah, it's like a neighbor's war. They're like, you know, like whenever, I don't know, this is outside of scope, but he would always inject himself into our lives, and he just wanted to make our lives more difficult.
In the side of their house, he called the cops. Thank God he's not there anymore. But like his last nice thing to do to us was call code enforcement because a property that we didn't know, we was not like following the rules. Honestly, we didn't know. I mean, it was there when we bought it. So what we're trying to do is get everything according to
Up
how
to
it's
code,
supposed to
up
be.
to code, yes.
So we don't have any other issue.
Okay, so I'm not sure what his specific issue, but code enforcement came out.
Right,
And once they got there, they said, well, your structure doesn't meet setbacks.
right,
Correct.
But if
exactly.
nobody was living there, I guess I should turn back to staff. If it was just an accessory dwelling unit, would it meet setbacks?
Yes.
Okay, so if code enforcement comes out and it's just a shed and it met setbacks, they wouldn't cite you for not meeting the setbacks. So why would they cite you for not meeting the setbacks?
We applied for a variance because they said that the building the way it is not legal, so they said that we have to apply for a variance so it can be legal. So that's what we did. We hired
When did you apply for the variance?
this year,
Before or after you got cited by code enforcement?
after we got cited.
Because we didn't know.
Yeah, we didn't know.
Okay, but code enforcement cited you for not meeting setbacks for an accessory dwelling unit.
Apparently, we pay whatever we have to pay according to whatever we was not following, because they cite us, we pay some penalties or whatever we have to do. And then they said, because we don't know, they say you have to go to a hearing because your property is not meeting the distance from the neighbors, from the back neighbor and the
The setbacks, yeah.
Yeah. So like, that's why we're here. Like, we kind of purchased that. We want to use that room because honestly, when we have people over, we don't have any place to put them. So we have that, a very nice set. We put a microwave, like we rebuilt the bathroom. It's very nice, right?
It's cozy.
But we want to use it. But if it's against the law, we need to find a way to kind of, because we don't have the money right now to kind of even move it. I don't know if that's possible. Or if we have to knock it down also, we don't have the money to do that. Okay. So we're trying to have everything according how it's supposed to, so we don't have any,
Yeah, so
we're not going against the law.
basically, when you guys came over, you guys didn't find any evidence of anybody living there. I remember in December, we were not even in the country when we had somebody knocking on a door asking to come in to look. I'm like, we're not even in the country, we're not here yet. And then 2 weeks later, after we arrived, then we got the notice saying that, that there's no evidence that anybody's living there, and they closed that case.
And then we receive a new case. I mean, thank God for everything. I don't know if you believe in God, but I do. So, thank you for everything, because now we can have this thing organized, but it's everything. It comes from somebody that doesn't have anything to do, calling the cops, calling the city. Like, this is not the first time they call the city on us, because whatever. So
All right, I
we're
get
just
it.
trying to follow, whatever we have to do to make it right,
We're trying to
that's
make
why
the
we're
best
here.
out of the situation, basically. So we're trying to, like, make sure that everything is up to codes. We wouldn't have any more problems with anybody.
All right, very good. Anything else?
No, we just
Okay.
request your approval, like everybody else said.
Understand.
Yeah, we kind of request your approval, and, thank you.
All right, thank you both. Appreciate it.
Thank you.
Could you come sign in, please?
At this point in time, is there anyone in the audience who wishes to speak in support of the application? There's no one responding. Anyone in the audience wish to speak in opposition to the application? Yes, sir. Yeah, please come forward. Morning.
Good morning, Mr. Luce. I did say that correctly, right?
Yes.
Okay. Good morning. My name's Brenda Noser LaKire. I'm one of the neighboring properties. I live at 17844 Morning High Drive. I'm here to respectfully oppose the variance requesting the necessary dwelling requirements. Over the past 4 to 5 years, the structure in question has undergone significant modifications and expansion. This building is substantially larger and taller than the original shed that existed on the property. It also appears to be equipped with a mini split or an air conditioning system, indicating that it may be intended for more than simple storage purposes. My concern is not only the size and scope of the structure, but the also apparent attempt to seek approval after years of construction activity. During this time, nearby residents have both been impacted with ongoing construction noise, often extending into the late evening hours. In addition to the structure, it includes cameras mounted on the rear of the building that face toward the neighbors' properties. While homeowners have the right to security measures in their property, the placement of these cameras raises a legitimate privacy concern for adjacent residents. I understand that variances are intended for situations involving unique circumstances or variances or hardships further related to this property. In this case, I do not believe sufficient hardship has been demonstrated to justify the exception to establish the dwelling. There is also a spectrum demarcation, which is our property, and I don't have the map. It's not a straight across. My property butts up to Terry and Amanda's, so it jags out. Probably 7 years ago, they hired 2 different attorneys to make us move our fence because it doesn't go straight across. There is in the corner a spectrum junction box, so I'm concerned because I have a shed there that has the variance that they're also going to want to take a portion of our property. There is a spectrum demarcation or junction connection located on our property behind the shed. Spectrum has indicated, Spectrum is actually owned by Coastal Communications, and I contacted higher ups to make sure, what the next steps were, and they refused to move it. I'm also concerned about the pattern of code compliance issues associated with this property. Prior code-related issues on this property raised concerns about whether future requirements or conditions would be considered following if the variance is granted. Granting this request would suggest that property owners can significantly alter structures over time and later seek relief from the requirements that apply to everyone else. Many residents work diligently to comply zoning regulations, permitting requirements, and code enforcement standards. Those standards should be applied consistently and fairly to all properties. And I went back and I actually contacted code enforcement. When they first moved in, the back fence, I could stick my hand through the fence and there was a pool there. They got fined for it and they had to take it down. Common sense, when you're going to put up something, you call code enforcement and hey, can I do this? They've also had other violations with chickens running loose in the backyard. And yes, the neighbor next to them, when you're facing their house to the left, there was a huge blow up and the guy sold his house and moved. And in closing, there's just been prior code enforcements, and they've been out there, and I'm sure you could look that up as well. I feel approval could affect the fair and consistent enforcement of zoning and permitting requirements for this neighborhood. I honestly think that there's someone living in there.
Yeah,
There
that's my question.
there hasn't always been water there. It was a shed. There was power, I believe, but there was not a toilet or a kitchen. The previous owners used it as storage. There might have been a washer and dryer out there. I don't know.
Okay.
My final point to emphasis, this request is not about whether an accessory dwelling is desirable. It's about whether the standards adopted to protect our community will be applied fairly and equally to all property owners. For property owners who follow the rules and invest the time, effort, and expense necessary to obtain permits and comply with local requirements, these standards exist to protect the neighborhoods that should be enforced, especially for everyone. For this reason, I respectfully request that the variance be denied and that the existing accessory dwelling requirements be upheld. And I'm sorry I shook through this, but thank you for listening.
Yep, that's fine. Thank you, ma'am.
All right, I need to sign.
Is there anyone else in the audience that wishes to speak in opposition?
Yes, sir.
Yep, please come forward.
My name's Amanda Alfaro. I
I'm
live on
sorry,
Morning.
wait till you get up
sorry.
to the podium. All right, go ahead.
I'm Amanda Alfaro, property 17846 Morning Heights Drive, and I'm here also against the variance on the dwelling. I live right behind the person, and if they do get approved for this dwelling, I think it is not fair to our community. What means we can also do the same thing to our own property. We can have our family live on our properties too, and I don't think that should be right. And also, with his property, there is a camera. We've called code enforcement. We told them this camera is in our backyard. I feel unsafe for it. We've never had any issues. And all of a sudden, he put a camera, it's directly right in the middle of my backyard where it should not be.
When
And
you
I
say
feel
cameras
unsafe.
in your backyard, it's facing your backyard.
Yes, it's on his building, and it's
Yeah.
facing into my backyard.
Got it.
Yes, we called him code enforcement, whatever code enforcement has told him. He slightly moved it, but it's still in my backyard where I still feel unsafe.
Let me ask the same question. The other person just spoke in opposition said she believes somebody's living there. Do you know if somebody's living there or not?
I don't know. Every night I see lights on and off. They keep changing colors. And I believe it could be somebody living there because sometimes there's lights on, sometimes there's not. It's just around the whole perimeter of that building that there are lights. And they have an AC unit on the back end where sometimes I do hear it when I'm like mowing or weed eating or just out in the backyard with my dogs. I do hear a little hum from this AC unit.
Ma'am, can you state your full name and address for the record?
Amanda R. Alfaro, property 17846 Morning High Drive.
Thank you.
And I'm hoping that this dwelling does get denied so our community stays niceful and peaceful.
Okay, thank you, ma'am. Is there anyone else in the audience that wishes to speak in opposition? Still on responding? Staff, anything further?
Just a couple clarifications for you. For the accessory dwelling unit, the permit that was submitted on the plans shows a kitchen, living room, bathroom, and bedroom.
Okay, got it.
So it's still in review, technically. The code compliance case, the complaint indicated they believe that someone was living there. The first inspection that was done,
The code enforcement officer thought somebody's living there?
the complaint that came in.
Oh, the complaint that came in, got it.
And the first inspection that was done by the code compliance officer indicated there was a failure to provide a residential building alteration permit for the renovations to the accessory structure.
Okay. All right. Anything else?
No.
Very good. At this point in time, the applicant has an opportunity for rebuttal.
I'm sorry that our camera bothers you.
Ma'am,
Didn't know.
ma'am, please just
I'm
speak
sorry.
into the microphone.
Sorry, but
Yes.
I'm really sorry.
Yeah, this is the first time we hear about any camera issues. We apologize. I thought
With
that,
that neighbor.
yeah, I thought
Please
it,
don't talk over each other either.
Oh, sorry.
One at a time.
I thought that basically, if a neighbor has an issue, they would come to us and let us know. We never heard about anything. If we have to move a camera, we'll move it. We'll be more than happy to do so. We just never heard of such a complaint.
Let me clarify something. The building outside, we did the roof because we remodeled the roof in our primary house.
I'm here.
So we remodeled the roof, I speak loud. So we remodeled the roof in the little building, but the structure, I don't understand if it's been there for God knows how many years, how it's been bothering them because it's always been there. And we've been living in that property since 2016, so since 10 years ago. So I do understand the camera, the lights, just to clarify something about the lights, they're motion sensor. They change colors. We like colors, so the light change colors, it's those new lights. And then if there's an animal, it is going to turn on, like those opossum or whatever. And the AC, yes, is gonna hum when we sometimes decide to sleep in there for whatever reason. It's gonna turn on, we're gonna turn on the AC. So yes, she's right about the lights, she's right about the camera, we can move it if it bothers somebody. And the AC is in there as well.
Yes, we put all of that in the permit, and it's all in process. We got all the permits that we need, and we apply for everything. I just want to say that, we apologize, but our neighbor in the back, they actually are encroaching in our property, and we went to the city many times. If you can see right here, it's kind of hard to see, but they are encroaching by, like 2 feet by 15 feet, and we talk to them very nicely, and all they do is curse us out. Or when we send the cable company to them, they've actually cursed them out and told us, to curse us out too. So it's been really negative with those neighbors back there, so we just left it alone. They are encroaching in our property, and they have a fence in our property where, I went to the city and I looked it up, and basically they have an easement. They're not supposed to build a fence, and they build it into my property. So I've allowed that to happen because I'm trying to be a good neighbor, but, now that we're trying to apply for a permit to make sure everything is okay, now they're making up lies saying that we altered the building. The building is, when we bought it, it's been like that, the same height, the same width. We just changed the color, and we had a permit to get the roof done.
No.
The roofing company made a mistake and didn't get a permit initially when we had the roof done for the whole entire house. And then when we review this, we went to the company, and they applied for after-the-fact permit to make sure that the roof was in compliance. So we're trying to do everything to make sure that this building is in compliance with the law.
Something else is that not the behind neighbor, if not the one we having the issue with the little space that they have their fence in our property. We sent them multiple letters. At one point, they called the cops on us because supposedly we went to their house and broke their door, like the screen. Thank God, for some reason, my husband was recording, and when the cop was there, we showed the video to the cops. We didn't do anything. He was even with my kids right in the bike. He drove the paperwork. I'm like, thank God he was recording, but the cops saw that we didn't do anything. So it's like trying to accuse somebody, and I respect whatever you decide, I understand, but it's kind of unfair because that has been how that can bother somebody when it's in my house, in my property. And the part for the fence, that's something for another day because it's in my property, the fence. And I don't want to go, this is something different, but you see that you're trying to demonstrate something when you're doing something different. So I don't know. I'm just trying to show that we are here in a good faith to try to get our things straight.
We're here in good faith, and we have, some police reports, like what my wife said, that they make some false allegations against us. And, we have evidence to support us, and that's why we haven't been to any court or anything. These neighbors that came by, they're very negative, and they've been cursing us out ever since we moved into our property. The first thing they said to us when we first moved in, I said, "Hey, hello, neighbor, how you doing?" And they told me, "F you, go away."
I don't know if they have confrontation with the previous neighbors.
We never met them.
We don't know. I don't even know who I don't know who they are, honestly. So,
Anything else?
anyway, no, that's it.
Okay.
No, well, thank you for your time.
All right, thank you both. Appreciate it.
Thank you.
All right, with that, that concludes this application. Ms. Marshall, we're ready for the next item.
Next item is item H3, variance 260905. The applicant is Talat E. Musa, trustee. The request is a variance to the Waimama downtown overlay standards and variance to lot development standards. Staff findings will be presented by Sierra James.
Okay, the applicant, please. I'm sorry, staff, please. Thinking of zoning.
Good morning, Sierra James with Development Services. The applicant is seeking a variance to site development standards in the Waimama Overlay District and the CN zoning district. They're requesting a variance to 60101 to increase the maximum impervious surface percentage by 10%, resulting in a maximum impervious area of 70%. A variance to 32306C1A to allow for parking spaces between the principal building and State Road 674. A variance to 32307B of 80 feet to allow for a maximum front yard setback of 100 feet. A variance to 32307D to allow building orientation and facade to face the parking area. And a variance to 32307H to allow for parking spaces between the principal building and State Road 674. I'm available for any questions.
No questions.
Thank you.
The applicant, please. Good morning.
Yes, good morning, sir. My name is Ryan Renardo with R Squared Engineering. Address is 10312 Bloomingdale Ave, Suite 108367, Riverview, Florida 33578. Got a variance request before you today for the Waimama Retail Project. This project is located on State Road 674, roughly a mile east of 301. Here's an aerial of the property outlined in red. You can see the western half of this property contains an existing building with some existing parking. It's been in place since the 70s, according to property appraiser records. This future land use for this area is OC20. Zoning, the underlying zoning is CN commercial neighborhood, but we are within the Waimama Downtown Sub-District B Downtown Center Overlay. It's a mouthful to say, so I'll just refer to it as the Waimama Overlay, if you don't mind. So basically, the gist of these overlay requirements are that they're trying to pull all the buildings to the front and put all the parking behind it. As you can see on the conceptual site plan, you know, my client purchased this property in the 90s, and they've always had a vision of adding a second building to the property. And when I started looking at this for them, you know, I gave them a couple options, and this was really the option that they had envisioned was having a second building in line with the existing building. So what you're looking at on this concept plan is on the left side of your screen, there's an orange, that's the existing building. There's some existing parking in the shaded asphalt or the shaded gray area. And then on the east side or the right-hand side of your screen, you can see where we're proposing the building location to be, where there's the parking that basically lines up, you know, with the existing drive aisle, a new north-south drive aisle. This allows for efficient vehicle movement, you know, in and out of the site. You know, we can easily connect pedestrians over to the existing building. Mind you, this is a conceptual plan. There's, you know, we still got to work through all the permitting. So there's
That's one of my questions for you. Have you started that review process?
We have not. The first step is we were hoping to get through the variance process before we got through all the detailed engineering work on this.
Yeah, because I think there's like this disclaimer somewhere from staff saying, you know, you haven't applied yet. You don't really know what all the issues might be.
That's right. I mean, we've done our due diligence. You know, we think that with a successful approval of what we're requesting today, I think we can make this plan work.
Okay. is it fair to say that the first variance is for impervious surface increase, but the other ones are all related?
Yes, sir. The four variances, they're pretty much all one, and you'll even notice in the narrative that I wrote, the justification, or the criteria are all basically for the same issue.
Right. I get it.
Okay. And so just moving through, just to run through it, these are all the variances that we're requesting. It's a lot. It feels like a lot, but it's all related to really the two separate issues. And then just for your reference, and I felt like this was an important visual as I was going through this. What you're seeing here, this is an aerial. The black outline that you can see represents the Waimama overlay that we're referring to. And then I drew a orange line across where our proposed building frontage is located, just to give you a visual of what's existing out there. And so all the way over to 2022, this building was built, and then moving over, a new building was just constructed in 2023, and then several buildings from around the same time frame in the 70s when our existing building was constructed. And so I think this visual is to say, hey, we're not really changing the character of this corridor. We're really more so in line with kind of what's out there now, and if we were to move our building all the way to the property line where the overlay is asking for, we would actually kind of be out of place here, to be honest with you.
Let me ask a related question. I believe 674 maybe in early stages of a PD&E study for the widening of 674. Do you know the status of that?
I do not know the status of that. The only thing I know about it, it's got a design speed of 45 miles an hour, which is really not a pedestrian-oriented roadway.
I guess I could look at it myself, but the cross-section, the existing right-of-way for 674, do you know what it is?
I honestly do not, sir.
Okay.
But that's definitely something that once we got through this phase, we would be dealing with FDOT as well in the next permitting stage.
Yeah, and I don't know if during site plan review process, staff will ask you to set aside X feet off the front for the future widening of 674.
Staff would ask us to confirm with DOT if there's any additional right-of-way required.
Okay, just keep that in mind.
Absolutely, yes, sir.
All right, anything else?
The only other thing I would add is that we sent the notices out to, the required notices, had no input either way, no opposition, no support, and then we respectfully request your approval of these variances.
Very good. Thank you, sir. Is there anyone in the audience that wishes to speak in support of the application? See no one responding. Anyone in the audience wishes to speak in opposition to the application? See no one responding. Staff, anything further?
Nothing further.
Okay. Applicant has an opportunity for rebuttal. No need for rebuttal. With that concludes this application. Ms. Marshall, we're ready for the next item.
Next item is item H4, variance 260927. The applicant is Sam Rex, Luminous Electric. The request is a variance to lot development standards, and staff findings will be presented by Michelle Montalbano.
Okay.
Good morning, Michelle Montalbano, Development Services. The applicant is requesting setback variances to accommodate 2 above-ground tanks per single-family residence. Per LDC Section 601-03I3 and PD 93-0357, mechanical equipment may project 3 feet or no more than 50% of the required rear yards, whichever is more restrictive. The PD district requires a minimum side yard setback of 10 feet. Therefore, a minimum side yard setback for the equipment of 7 feet is required. And there was a typo in my original report. It says 4.5 feet where it should say 7. So therefore, the variance they're requesting is for 3 feet, resulting in a 4-foot side yard setback for mechanical equipment. Per the same code sections, mechanical equipment may project 5 feet into required rear yards. The PD district requires a minimum rear yard setback of 25 feet. Therefore, a minimum rear yard setback of 20 feet is required. The applicant is requesting a variance of 8 feet, resulting in a 12-foot rear yard setback for mechanical equipment. I'm available if you have any questions.
No questions, thank you.
Okay, thank you.
All right, the applicant, please.
My name's Chris Brundle, talking on behalf of Luminous Electric. Our address is 3165 Lakewood Ranch Boulevard in Bradenton.
I'm sorry, sir, can you repeat your name?
Chris Brundle?
Okay, very good, thank you. Go ahead.
Yes, sir. We're just asking for a variance here on Mr. Petrillo's property. There is really nowhere else to put these above-ground propane tanks. He has purchased a whole home generator, mostly for medical reasons. And we put these tanks in a location that we thought was appropriate.
All right,
They are off
yep.
of,
Hold on a second. You said, I was trying to understand the purpose. So it's not for a swimming pool, heating the swimming pool, it's for medical purposes?
yes, it's a whole home standby generator.
Okay, but if I heard you correctly, you said medical purposes.
Yes.
Okay, all right, go ahead, proceed.
So we're asking for a variance to place these tanks a couple feet from the property line, from the side yard and the backyard, 10 feet closer to the backyard variance due to no other, not being able to place them anywhere else on the property.
Okay. Just curious, what size are these tanks, if you know? Are size of bigger than a bread box? Give me a general idea.
They're 32 inches in diameter, and they stand about 5 feet tall.
Okay, so they stand upright.
Yes, sir.
Got it.
And they are anchored down, and everything is up to code besides placement per jurisdiction.
All right, very good. All right, anything else?
No, sir. Joe?
Very good. At this point in time, is there anyone in the audience who wishes to speak in support of the application? Is no one responding? Anyone in the audience wishes to speak in opposition to the application?
Can I be heard?
Yes?
Yes, I'm the applicant and the homeowner.
Yes?
I'm not sure if you can see me.
I can see you, and we can hear you.
Okay. I'd like to say,
Sir,
I'm the homeowner at 7.
Sir, but please state, I know you said you're the applicant or the owner, but please state your
Yes.
name and address for the record.
Yeah, yes, my name's Joseph Petrillo.
Okay?
I'm at 7517 Dunbridge Drive.
Okay.
I'm the homeowner requesting this variance as applied for by my contractor, Luminous Electric, who just spoke.
Yep.
I wanted to add to the variance criteria response on page 9 with the variance that the tanks would have to be moved to the north side of my house against the house, and a propane line piped more than 100 feet through my attic, which in my opinion presents a potential hazard. And if you would note item 5 on page 9, that the location of the tanks passed the final gas inspection. At that time, we had the tanks filled. The final electrical county inspector came and said the tanks are too close to the property lines when they've already, the final gas inspection was already passed. And as Chris mentioned, on a personal note, my wife and I are both 76 years old. We have several health problems, including, but not limited to, anemia. We have diabetes, heart disease. We have some spinal issues. In the event of a power outage without a generator, we'd be forced to seek shelter. At our age, that'd be, and at our age and our health problems would cause a considerable hardship. So I would please consider this variance carefully. Thank you.
Very good. Thank you, sir. All right. I think I left this also. Proponents, opponents, and so staff, anything further?
Nothing further.
Okay. And the applicant an opportunity for rebuttal? Oh, online. Sir, we good? Contractor?
Yes, sir.
All right. Very good. With that, that concludes this application. And Ms. Marshall, we're ready for the next item.
Next item is item H5, variance 260992. The applicant is Alvin Devet Baldwin. The request is a variance to distance separation requirements for a community residential home. Staff findings will be presented by Chris Granlard.
Yeah. Good morning.
With Development Services. The applicant is requesting a variance to the distance separation requirement for a Type A community residential home. The Land Development Code requires that community residential homes housing 6 or fewer residents be located at least 1,000 feet from another existing home of the same type. The applicant is requesting a variance to allow their proposed home at a distance of approximately 560 feet, resulting in a 440-foot separation from the existing community residential home on Knight Street. That concludes my staff report. I'd be happy to answer any questions you might have.
Could you go back over the distance separation? When you looked at this, do you look at walking distance or rather than a straight line distance?
It's just a property. It's property line to property line.
I know, but from a practical point of view, do you not take into consideration the actual route of travel between properties?
No, that's not considered. It's as the crow flies.
Yeah. Okay. But would you consider that a mitigating factor, in your opinion?
It's for you to decide, sir.
Understood, but I'm asking your opinion.
I don't know if I could answer that, sir.
Okay.
Colleen, could I?
Fair enough.
Should I answer that? Colleen?
Can you repeat the question?
Yes. Do you consider route of travel as potentially a mitigating factor to consider?
Could be.
Yes.
We do, for alcohol beverage license separations, we do
Yeah, for
look at
that.
that.
Right. All right. That's not. Thank you.
It's for the chair to decide.
At this point in time, the applicant.
Thank you.
Good morning. My name is Alvin Baldwin, 505 Rooks Road, Seffner, Florida, 33584. Here requesting a distance variance for an assisted living facility. I have a group home, a APD licensed group home that's 606 feet away from me using the straight line method. If we drive, it's 1,023 feet away from me. The community residential homes are supposed to be 1,000 feet apart. I'm asking for you guys to give me a variance because we're going under two different agencies. That home is licensed through APD. I'm going to be licensed through ACA, the Agency for Healthcare Administration. They're a group home for behavioral adults. I'm doing elderly adults, elderly population. So I'm trying to get a distance variance of 460 feet.
Okay. Anything else?
No.
Yeah. Thank you, ma'am.
That's it. Thank you.
Ma'am, could you come sign in, please?
At this point in time, is there anyone in the audience that wishes to speak in support of the application? Is no one responding? Anyone in the audience wishes to speak in opposition to the application? Is no one responding? Staff, anything further?
Nothing further.
Ma'am, an opportunity for rebuttal? No? Very good. Very good. With that, that concludes this application. Ms. Marshall, we're ready for the next item.
Next item is item H6, variance 260994. The applicant is Michelle Tolini. The request is a variance to distance separation requirements for a community residential home. Staff findings will be presented by Sierra James.
Good morning, Sierra James of Development Services. The applicant is requesting a variance to minimum separation requirements for a Type A community residential home. The requirement is a radius of 1,000 feet between an existing home with 6 or fewer residents. They're requesting a variance of 36 feet, resulting in a 964-foot distance separation between the existing community residential home.
Okay.
Available for questions.
For questions. Thank you. And the applicant, please. Good morning.
Good morning. I'm Michelle Tellini. My address is 5700 92nd Avenue North, Pinellas Park, Florida, 33782. I'd love to put on the record first that the zoning team has been amazing. This is my first time ever, and they walked me through and held my hand, and they were fantastic. So thank you. I am requesting a 36-foot variance on a home that I believe to be outside the distance. It's about 0.3 miles if you're driving. Google gave me straight line as 1,075 feet, but the zoning tools are much better than what's open to us in the community. I am trying to move my existing group home that's about half a mile away that we rent to this home that I purchased to move my residents to. It's a nicer home. It's a lovely community. And you know, my job is to teach them to be good neighbors and good citizens. The house is only half a mile, so there's no impact on my staff. They really won't have to travel any further. It won't disrupt the day activities for the men that live in my homes. So I just would be very thankful if you could, so my gentlemen that live with us with disabilities would be able to have a better life. So thank you.
All right, thank you, ma'am. Is there anyone in the audience who wishes to speak in support of the application? Morning.
Good morning. My name is Gary Hartfield. My address is 5125 Palm Springs Boulevard, Tampa, Florida, 33647.
Okay.
I have known Michelle Tellini and the company that she owns for the last 20 plus years. She has worked for the Agency for Persons with Disabilities and worked with this client population for a significant amount of time. Her reputation precedes her as being a leader in this field, and the men that she provides care for in these group homes would definitely love the idea of a nicer home. What we do in this field is provide our clients with dignity and respect for the intellectually and developmentally disabled. I am myself a provider, and I have been one for the last 25 years. So I speak in solid support of Michelle Tellini and her company that she represents.
All right, very good. Thank you, sir.
Yeah.
Is there anyone else in the audience who wishes to speak in support of the application? Is no one responding? Anyone in the audience wish to speak in opposition to the application? I would, sir. Yes, sir. Please come forward.
All right.
Good morning.
Good morning, sir. My name is Michael Ryan, R-E-I-N. I reside at 902 Stanberry Drive, Brandon, Florida, 33511.
Okay.
This property is adjacent to the property that we're speaking about. It is a corner lot. I do know that we do have special needs people in that area that have been there since I purchased the house in 2007. I purchased that house because I wanted to bring up my children in a safe environment where no cars, traffic, things of that sort, because it is a back off the main drives of Kings and Lumsden. I also noted that the Zoning Commission has changed some of those properties because of the drive. When they widened Lumsden Drive and things, they put in a hairdresser and such on the corner. Understandably, they had to take and adjust the property for more parking and such. This is one of my concerns with this, since it is a 4-bedroom house, that they would have to change the parking in there, making it more of a business type instead of a residential. This is a very quiet, older neighborhood. My house burned down during Milton. I spent over $600,000 to rebuild that house because I love that neighborhood. Unfortunately, some of the rezoning that we've seen in the past here with elderly people passing, people selling the property, they rezoned them. Unfortunately, what I've seen over these past 10 years when they've done that is that they haven't kept up with that. I have brought that up to code enforcement also. These were supposed to be business only, as in legal or doctor's office, things of that sort. Unfortunately, they just put residents in there, rented the property out. So again, it's happening at this time. Where they're proposing this house to be changed into this is in the center, not on a busy road like Lumsden or Kings Drive. where I understand once they moved the roadways and that made their properties much smaller. The other thing is that I've noted that we have approximately 5 homes, and these are assisted living homes within a 2-mile radius of this. We always, every time I'm going down Kings, go to the Publix and such, I always notice ambulances, always in and out, unfortunately, for things that do occur with elderly and such, which I do understand. This, to me, will make it harder for us to live in a residential area with these type of vehicles in and out, unfortunately, does, again, happen. So I do respect your zoning. I hope you take this under advisement, and I thank you very much for your time.
All right, very good. Thank you, sir.
Yes.
All right, is there anyone else in the audience who wishes to speak in opposition? Yes, sir. Good morning.
Good morning. My name is James Rolls, and I live at 418 Overland Drive.
Okay.
So I would just note that this area is a desirable area because it's close to the hospital, and I understand that, people who need assistance need a place to live. But the neighborhood vibe is a family neighborhood, and these are for profit or nonprofit, but they operate them like a business. The first thing they're going to do is add a big driveway, have a staff, the parking's going to go onto the street. This street doesn't have parking on the street because people don't need it, because they're single-family homes. And there's already a couple of assisted living homes in this area, and it's going to create more traffic of the people who go to these assisted living homes. They have to be there at a certain time, and they have, shifts that they have to be there. And so it's creating a work-like environment in this neighborhood. And all these little streets are connected. I'm not very far from this, but it's in the center of this street. And they could much more appropriately go at least to Lumsden or Kings and pick a house that's on the end of the street instead of in the middle of the block. And so I wish that you would consider those issues and how it affects the people that live in this neighborhood.
Yeah. Very good. Thank you, sir. Is there anyone else in the audience that wishes to speak in opposition to the application? See no one responding. Staff, anything further?
Nothing further.
Okay. And the applicant has an opportunity for rebuttal.
Yes, I would like to provide a rebuttal, and I understand having a group home on your street can be scary. I do, but these are individuals with disabilities. It is going to be a 6-bed residential group home, and underneath statute, it is residential, not commercial. It's not an assisted living facility. The neighborhood is lovely. I think there's mostly original owners to. I'm sorry. I understand there's mostly original owners, so it's an older neighborhood. It's currently zoned R3, so there are not a lot of houses, and they're nifty because they all kind of angle away from each other instead of directly facing. There is a very long driveway, which will accommodate the majority of the parking. Yes, probably the worst part of having a group home is your neighborhood is that you're going to see cars because my clients are staffed. We have awake supervision up to 4 people on, but it's also a large driveway on the side of the house, which I did factor in. It's not commercial. I'm not about the money. I would give everybody my personal cell and the people that monitor us. And one of the nice things about being an APD group home as a neighbor is that I have someone monitoring the property from the state of Florida monthly. They are holding me accountable to Florida Administrative Code 65G2, which goes into depth that makes sure that the property is in better condition than if I rented it to some stranger off the street. So I will do everything in my power to be a good neighbor, regardless of the outcome. But I love the house, and it's a great community, and our goal is to be good neighbors. So thank you.
All right, fair enough. Very good. Thank you, ma'am. All right, with that concludes this application. And Marshall, ready for the next item.
Next item is item H7, variance 26-1099. The applicant is Hush Govey, Northside Engineering Incorporated. The request is a variance to the Citrus Park Village development standards and variance to landscaping and buffering requirements. Staff findings will be presented by Sam Ball.
Okay.
Good morning. Sam Ball, Hillsborough County Development Services. There was a typo on the staff report. Underneath the column for variance, it says relief from section 606C. That should be 606-4C.
Okay.
The applicant is requesting basically two variances for requirements for perimeter buffering adjacent to a road right-of-way for a property located in the Citrus Park Village overlay. LDC section 31010C requires off-street vehicle uses shall be buffered and screened in accordance with section 60603 of this code, basically except for the plantings must be 10 feet in height, 3-inch caliber, and placed 30 feet off center. The applicant is requesting relief from section 606-4C, which would result in relief from the requirement for vehicular use area buffering along the southern portion of the western property boundary and the minimum height, caliper, and maximum spacing requirements for this area. Section 606-04C requires an 8-foot vehicular use buffer area along the western boundary. The applicant is requesting an 8-foot reduction to this requirement, which would result in site development with 0 buffer along the southern portion of the boundary as shown on the site plan. I'd like to add that the upper Tampa Bay Trail is considered a road right-of-way, and because it is a right-of-way, it adjoins the subject's property's western boundary and is at least 50 feet in width. The incompatible use buffering along the western boundary is not required. I'd also like to add that variance 250277 was approved to reduce the eastern vehicular use buffer requirement from 6 to 0 feet along the eastern property boundary. That concludes my report. If you have any questions.
No, not this time. Thank you.
Okay, thank you.
All right. The applicant, please. Good morning.
Good morning. My name is Hushko Vahi. I'm with Northside Engineering. We're located in Clearwater, 300 South Belcher Road. Thank you, Sam, for eloquently describing the project. We're just basically merely requesting a portion of that western right-of-way to be reduced to 0, just because the width of the property is very, very minimal, and we're trying to create a turnaround when patrons will be using this ice cream shop that have to basically get around the building to order and pick up, and even at the design that we have is pretty minimal, so we're requesting only that portion, which we showed to be 71 feet. That also includes the transitional part. As you get from, let's say, 8 to 0, there's a portion that cars would have to transition into that. So generally speaking, just a 71-foot on the west side of the property. And as Sam also alluded to, we had requested a 0 setback on the east side wall back. At the time, we had a different design and didn't need it. But this particular design, we really just need to be able to accommodate the vehicular use.
Okay.
I'm glad to answer any questions.
If you know, where are you in terms of commercial site plan review process?
It is in the process. We have submitted plans. We have received comments. And once, hopefully, if this is passed, I would say in the next couple months, hopefully, we should obtain the permit.
Okay. The upper Tampa Bay Trail, which is adjacent, the actual asphalt where bicycles are located within the trail itself, I mean, there's a right-of-way width,
yes,
and then there's a trail itself. How close is the trail to where
the edge of
the
pavement?
shop, circular driveway, the queue area? How close are those cars?
I'm going to give you a guess. I would say probably 15 feet edge of pavement to the trail.
Yeah. I mean, that was the only safety issue I could see is, I don't know how many people actually pass by that location on bicycles, but.
Yeah, and of course, in this case, as you know, cars are generally stopped. They're just not moving fast.
They're going pretty slow, but it's true.
Yes.
Okay, and in terms of design, the design that they're moving forward with, there is no idea of having cars park and walk into the ice cream shop?
We have parking spaces shown on the property, as many as possible. I think it's 7 or so.
Okay.
But most people would either be walking there because it's a neighborhood commercial kind of a design, either through the trail. They would be on their bicycle, maybe wanting to stop and grab a coffee or, ice cream. Lots of pedestrian use is anticipated, but of course, cars can also be driving through there to pick up their ice cream and leave. We recently developed the car wash immediately to the west of this ice cream shop, and that's working fine.
Okay. All right, that was the concern I had, is that how is this use being orientated towards the trail and the safety issues and accommodating people that want to park their bikes and walk into the shop, and are there any conflicts with the drive-through?
We have adequate accessibility as far as pedestrian. We have a sidewalk that goes from the parking to the building, a couple of ramps, and we also have a bicycle rack there.
Okay, and is there a crosswalk across the drive-through?
Yes.
That allows people to safely get to the shop?
Absolutely. It has to be there for the ADA anyways, but other people can use it as well.
Yeah. All right. No further questions.
Yeah. Thank you.
Thank you, sir. At this point in time, is there anyone in the audience who wishes to speak in support of the application? Is no one responding? Anyone in the audience wishes to speak in opposition to the application? Is no one responding? Staff, anything further?
Nothing further.
Okay. The applicant, an opportunity for rebuttal? No need for rebuttal? All right. With that concludes this item. I believe that's the last variance on this morning's agenda. And the last item is for special use. And just give me a second to read in the process for special uses. All right. The last item on this morning's agenda is a special use. And the order of presentation is slightly different. With respect to special uses, the applicant will have 15 minutes to present their case, and Development Services will have 5 minutes to present their position. I don't know if the Planning Commission weighs in on this one or not, but then they'll have an opportunity to make their findings. They have 5 minutes for that purpose. And those people that are in support of the application will have 15 minutes to speak. And then those people that want to speak in opposition will have 15 minutes. And Development Services will have an opportunity to address any comments. And finally, the applicant will have an opportunity for rebuttal, and they'll have 5 minutes for that purposes. With that, Ms. Marshall, we're ready for the next item.
Just a section I, special uses. Item I1, special use 260219. The applicant is Todd Pressman. The request is a special use for a school, and staff findings will be presented by Jared Fallen after presentation by the applicant.
Okay, the applicant, please.
Good morning, hearing officer. Todd Pressman, 200 2nd Avenue South, number 451 in St. Petersburg. I'm very proud today to be working with the Foundation Christian Academy for this request. We have our transportation expert here and some of the board members. We have the principal of the school. Man, I've been out of high school for, 50 years, and there's a principal here. It still makes me nervous.
Same here.
So this is SU SCH 26-0219. The Foundation Christian Academy is affiliated with the Churches of Christ and shares a commitment to Christian values and biblical teaching. Just giving an orientation of the direction of the school and how the school operates. They note 16 persons or 16 students with average class size. They have a 100% college acceptance rate, 35 number of extracurricular opportunities. Located in the general Lithia area on Lithia Pinecrest, as you can see here, which is south of 60, and a little closer view of the campus, and closer yet still, and just another view of the existing campus. Has a history as the school has grown slowly over the years. Today's issues: special use for school. Number one is to increase the square footage from 55,433 to 135,433 square feet. In terms of future long-term growth, as they've had to come through in the past, this is really a long-term plan, which will increase student population from 550 to 1,000 students. We'll talk about that more in detail, and to add 2 small ball courts. So in terms of projected student population, and this letter is in the record as well as here, the historical annual enrollment is 19.8 students per year. Some years they have more, some years they have none. So it will vary over time, but that has been the established historical element of past growth, which there's no reason to think it would be different. So projected growth through 2028, 2029, 2030, maybe even further, would be 19.8 students per year, has been experienced in the past. This is the special use site plan on Lithia Pinecrest. These are the proposed new facilities, which are multi-use buildings and 2 ball courts. This is the location and aerial of the 2 proposed ball court locations. Their current ball fields to the north. I have the measurements per Google mapping to the closest residential at 418 feet and 484 feet of those 2 sports ball courts. And looking a little closer to indicate to you that the ball courts are adjacent to very dense, high and wide forestation, giving an idea of what that looks like. See, there's high and low, so it covers obviously tremendously higher, tremendously more dense than what code would require. There's a drop-off and pickup data for morning and afternoon. There's a significant circulation plan. Mr. Razor, Transportation, and the school could refer to better detail that, but it's a very specific circulation plan, so it's very efficient. It's a little closer look for it. There's a lot of detail to it, a lot of safeguards to it. We did have a private planner, Ortiz Planning, look through the criteria. In terms of the 2 criteria, she's confirmed that we do meet those criteria under code and what's proposed with Lithia Pinecrest as an arterial roadway. And Lumsden to Fishhawk identified the MPO long-range plan, and the location arrangement, lighting of play fields will avoid interference, which, as she's looked at and approved in her report in the record, found that to be sufficient. Development Services Department, in their report, notes that they do not expect to have significant impact on the surrounding area. It's adequately buffered by either existing vegetation, required buffer and screening. Development Services indicates they find no issues with the proposed changes to the existing private school and do not foresee any negative impacts on the surrounding residential uses. Planning Commission notes that it's compatible with the existing development pattern, will allow for development that is consistent with the codes, future land use element and comp plan, and the proposal is compatible with adjacent uses, maintains the character of the community. They continue to note as well, the actual amount of square footage is under the Res 4 designation for this site, and accordingly, the proposed development is consistent with a number of objectives and policies indicated in their staff report. So with that, we appreciate your attention. We're happy to answer any questions, and we have our folks here in the school as well in representation.
All right, does the principal want to come up and admonish everybody in the room?
I've had plenty of experience with that, but with respect, if I may have Mr. Razor come up and make a few comments.
All right, very good.
Thank you.
Thank you. Good morning.
Good morning. For the record, Michael Razor with Razor Transportation Consulting, 19046 Bruce B. Downs Boulevard, number 308, Tampa 33647. I'm a registered professional engineer with a specialization in traffic. We performed the transportation analysis for the project. We identified that, well, let me take one step back. Currently, the ingress and egress for the school is from Lithia Pinecrest Road. It will continue to be the case with the expansion of the school site. Currently, a LEO, law enforcement officer or officers, are used to facilitate the ingress and egress operations at the school connection to Lithia Pinecrest Road. With this expansion, the continued use of LEO traffic control is anticipated until such time that a traffic signal is found to be warranted at that connection. There's conditions of approval that will require a traffic signal warrant for each increment of development. One thing that we did learn as we did the traffic study for this site, the law enforcement officer, similar to letting out a concert or a sporting event, as you know, schools generate a lot of traffic during a relatively small window of time and relatively little traffic for the rest of the day. During those periods, the law enforcement officers are used to safely and efficiently move traffic in and out of the campus, or on and off of the campus. We have identified through the course of our analysis that the current law enforcement officer traffic control set up and the way that they are flushing the traffic out of the school may not be as beneficial to northbound and southbound traffic on Lithia Pinecrest Road. But we've identified that, and we've talked to staff and their law enforcement officers that control the traffic to regulate that in a more efficient manner for Lithia Pinecrest Road. More importantly, with the traffic signal that I had mentioned for each increment of development needs to be evaluated to see if it's warranted, and I fully anticipate that it will be. At the time the traffic signal goes in at the cost of the developer or the school, the county will then be able to control the amount of time that's given to the school versus Lithia Pinecrest and be able to, you know, they'll be the ones that control that time allocation. With the traffic signal in place, our analysis identified that all, you know, level of service, volume to capacity ratios all fall within acceptable ranges. One other thing I'd like to note, that there, in addition to the traffic signal, relatively substantial turn lane improvements would be required as well. Currently, there's a northbound right turn lane to enter the school, a southbound left turn lane to enter the school. Our analysis identified that those turn lanes will be too short for the full population of the school, so we've identified lengths that would need to be implemented in association with this proposal. Also, Lithia Pinecrest Road, as I'm sure everyone seems to be aware, there's, you know, it's a heavily traveled road. Planned to be 4-lane for quite some time. However, as I understand it, Commissioner Miller has taken on getting a commitment from DOT for $100 million of the $250 million price tag. So typically when money like that starts flowing, it's a snowball effect, and the prioritization of that project continues to grow. So the 4-laning of Lithia Pinecrest, my understanding is that it's early 2030s where things will really start to happen on that. So that road, while the need has been there for a while, the solution is coming. And with that, I'd be happy to answer any questions.
Yes, regarding, it's in the MPO plan, Lithia Pinecrest, but there's no dates yet set for design and construction, land acquisition, construction, as far as you know?
My understanding is there's typically for a road construction project, there's typically 3 phases. There's the planning and design.
Yep.
There's the right-of-way, and then there's the construction. My understanding is that the only thing that is funded at the current time is the initial phase.
Okay, which is?
The planning design. Mm-hmm. Correct. And I don't have anything further to add to that. Yeah. Other than maybe it's speculation, but yeah. Typically I've been involved in this business for 30 years, and when the DOT allots $100 million towards a project, right, folks typically would get on board to get that project moving.
Yeah. you indicated that 100 million may be allocated by DOT, and the entire improvement will cost 200?
I believe it's just shy of 250
All right. And that money has not yet been found?
allocated, correct.
All right. You also mentioned that you've talked to the law enforcement folks.
Through the school folks.
Through the school folks, that there may be a better way or an enhanced way of directing traffic until such time a traffic signal's there. Could you elaborate? What do you mean?
Sure. I mean, the current operation, just to give you just a simple example, if there's a handful of cars queued up waiting to leave the school, let's say 5, they will, stop traffic on Lithia Pinecrest, let those 5 go, maybe another 5th or 6th or 6th or 7th straggler comes in. It's just not very efficient. Typically, the way a traffic signal would operate is what we would like to see the law enforcement officers do. Larger queues on school site, Lithia Pinecrest runs uninterrupted for a longer duration in between the cycles of flushing out the school.
Almost like an interconnect of the signals?
That in signal interconnects enhance efficiency, and that's what we're trying to do here as well. Right. So this proposal instigated, of course, required the traffic study, and then when we got into it, these are things that we learned and have expressed back to the school to improve their current function.
I don't think there's a zoning condition that says currently, until such time there's a traffic signal, that the law enforcement shall do more enhanced directing of traffic.
The condition, I believe, indicates that the law enforcement will continue to direct traffic until such time.
Right.
However, we understand it's the school's interest to make sure that that is operating efficiently.
With respect to the on-site queuing,
So I did not address that. The on-site queuing has been designed to meet the land development code requirement, which is the formula that you may or may not be aware of. It's a formula that ends up with 2 miles. I'll ask David Bell here in a moment. About 2 miles of on-site queuing. That's a guess at this point. I'm asking David to confirm. 6,200 feet. So I was a little shy, but over a mile, 1 point something miles.
and since it's an existing school, do we have any evidence that whether or not it works okay or doesn't work okay? Existing on-site queuing.
My involvement as the traffic consultant and pursuant to the requirements of DRMP really looks at the interface between the school site and the public road system. I don't have any firsthand knowledge or awareness of how that's operating internal to the school at the current time. However, with this proposal, the drop-off and pickup function is going to be improved as well with a different circulation pattern through the school to make that as efficient as possible as well. So there are on-site improvements. Right. There's the off-site improvements. Again, traffic signal anticipated to be warranted with longer turn lanes.
Okay, as a charter or private school, I mean, I assume everybody's driving to the site.
Generally, that is the case, correct. Yeah, there's not bus service.
There's no bus service.
Correct.
Right? Is there any walking? Is there any walking, biking?
During our data collection observations,
right.
Minimal at best.
Right.
So it's a vehicular parent private automobile drop-off pickup function.
And is anybody on your team or Mr. Pressman's team, do they have any knowledge about how the existing on-site queuing works?
I might be able to defer to the school folks for that. Okay. Maybe the principal can come.
Is this the principal?
Good morning.
Sit up straight.
My name is Jonathan Smith. I live at 10117 Deep Brook Drive in Riverview. And I am the principal at FCA. In addition to my administrative duties, I'm in the car line every day, supervising the flow of traffic. Right now we have 4 queues on the back of our property. So our first objective is to get all the traffic off of Lithia into one of our queues. Those queues would be preschool and kindergarten, elementary, middle school, and high school. And these queues operate at different times. So we release the kids in 15 to 20-minute intervals. That's about how long it takes us to empty one of the queues. So they're staggered.
So you're saying that for different age groups, there's a staggered
Yes, sir.
Drop-off and then pickup times?
Yes, sir. In the morning, middle school and high school drop off at beginning at 7:10. Then elementary drops off at about 8:05.
Okay.
In the afternoon, the middle school car line is first. They pick up at 1:56. At 2:15, the kindergarten parents arrive. 2:30 is elementary, and 2:46 is high school.
All right. And in your evaluation, observation, is it there's no queuing to drop off or pick up that goes out on Lithia Pinecrest Road?
Correct. Correct.
Okay.
Yeah.
As far as you know, on-site circulation works.
Yes, very well. And our officers do a tremendous job trying to time the traffic to keep it from backing up. We've been on this property since 2005, so our closest neighbors back then were the horses that lived in the horse farm across the street. Yeah. We've been a part of this community as it's grown, and we've very much enjoyed that growth. On the days that we do not have an officer, traffic still seems to flow on and off of Lithia without backing up significantly onto our property. Right now, all of the queues that we have run effectively. The holding queues in the back of the property are where the parents wait. The loading queue, the loading queue holds about 20 cars. So we're able to load 15 cars at a time.
Okay.
And then as they exit, we pull from the loading queues.
Okay.
Sounds complex, but it's really quite effective.
All right. And your transportation folks or your site plan folks have looked at the expansion.
Yes.
And they believe that with the expansion plus background, that the queuings will still work.
Yes. So I have 3 members of my administrative team receiving cars. We have the officer on Lithia, and then we have 3 checkpoints where we sort the traffic into these queues. Okay. And even with the expansion, I could potentially add a 4th traffic supervisor in one of those queues. Okay. But on our side, seamless.
All right, very good. Thank you, sir.
Yes, sir.
Appreciate it.
Sir, could you sign in, please?
And to that, let me add that while there is staggering occurring, the Land Development Code requires the queue area to assume all vehicles arriving within one period. So it's substantial, and there's plenty of area on site to accommodate all those vehicles for one period, much less the 3 to 4 staggered periods.
Got it. All right.
Thank you.
Very good. All right, with that, Mr. Pressman, does that conclude your team's presentation?
Yes, sir. Thank you.
All right, thank you. All right, staff?
Thank you, sir.
Jared Fallon with Development Services. I have a revised staff report I'd like to submit. There was a couple errors with the numbering, specifically with the number of children that they're proposing. Originally, staff report says 1,100, should be 1,000. And the number of proposed square footage increase was stated as 81,000, and it should have been 135,000. So I'm going to submit that too.
Okay. Thanks.
So yes, this is a request to obtain a special use permit to increase the number of permitted students for an existing private school and childcare from 500 to 1,000 students. This permit also seeks to increase the permitted total building floor area from 55,433 square feet to 135,433 square feet. This private school, its foundation, Christian Academy, was originally approved by special use 03543 and was most recently approved by special use 14828. Development services, we really didn't have any issues with this one. The site, it's appropriate for a school, it's mixed residential. There's no compatibility concerns that we have with adjacent properties. The existing buffering screening is being maintained. There's no changes to that.
All right, well, let me ask you then, the zoning conditions that are in the staff report, I don't think they're strike through and underlines, so maybe if you can just walk me through them.
So it is a new special use, so it's basically a new condition, so we don't do a strike through.
Right. All right, so then just reword my question is that, what's new?
So the students is being increased from 500 to 1,000.
Right.
And the maximum square footage permitted is being increased to 135,433 square feet.
That's it?
That's it.
So only zoning condition number 1 is essentially new.
I think there are some transportation changes as well. And also the site plan change as well to show the new proposed buildings.
Right. Okay. Is there a traffic person here from the county?
Yes.
All right. Unless you know, do you know which traffic conditions are new?
I don't know off the top of my head. Right. I think she's coming right now.
Okay. All right. Anything else?
No.
Okay. Very good. All right. And if there's a development services transportation planner here?
Yes, sir. Jessica Kowal with Development Services Transportation Review Section.
Okay.
Here to answer your questions.
Yes, if you could. I don't know if you've seen the zoning conditions, but if you could walk me through them. And I don't know if you knew what was approved before and now what's being proposed and what's new.
So most of those conditions, I shouldn't say most, a handful of those conditions are standard for all of our schools. It requires the law enforcement officers to be directing traffic if we see that it is warranted on major roadways. Things such as the Public Works Department assessing their queuing plan, assessing how it works. If there are problems, the applicant and developer can work with the Public Works Department, not have to go back through this process just to alleviate the traffic concerns and the circulation if there are potential concerns. A few things about this specific project. The Lithia Prime Crest is, like you mentioned, slated for improvements for the four-lane widening. At that time, the applicant will have to basically will have to take their right turn lane out and relocate it. For this specific application, they are required to preserve right-of-way for that four-lane widening. In addition, they will be required to dedicate any widening for their turn lanes and the signal widening in addition to the preservation. Also, the impacts, like the applicant mentioned for the queuing, we asked the applicant to add a delineator in between the two entrance aisles so that we don't have a weave and merge issue that can create a slowdown in the queuing circulation. The very first entrance to the school off of their shared access will be gated during drop-off and pickup time, which will force the vehicles to go all the way through their site, around through the big fields in the back, so that there is adequate stacking for these vehicles coming in and out. There's other items such as another trained staff member in a different location than is currently proposed, and that is to, again, assist with getting people to merge and then exiting. So the setup is quite similar, but we have done a few tweaks in that front part where the existing parking lot is to make sure that there isn't any more stop conditions that would prevent the flow of vehicles into the site. We did observe that some citizens had complained about the amount of traffic that is let into the site, not so much out of the site. So like the applicant's representative, Mr. Razor, had mentioned, they have worked with the law enforcement officers, and the school has worked with Public Works, and they are working on a more efficient way of queuing their students currently, so that isn't as drastic of an issue for the people utilizing the roadway.
All right. And as far as you know, do you know if the county's engineer or your staff, have they met with the folks that direct traffic out there to give them guidance?
I do not believe they have directly met with the people who are directing traffic. Typically, we ask that the developer work with the law enforcement officers and public works, because they know their operation better than we do.
Okay.
They do bring our staff into discussions if warranted.
Okay. All right. In terms of a traffic signal, the applicant transportation planner said that he anticipates a traffic signal will be warranted, but he didn't give us a date. I mean, I guess that's based on the growth of the school.
That is correct, sir, yes. We can't really do we can't really trigger the signal until it's warranted, and in the conditions for this special use, they are required to do a traffic signal warrant analysis at each increment of development and with any increase in the student population.
Is there any estimate? Now, they're going from roughly 500 students to 1,000. Do you know, does it get there at 750 kids? Does it get there at 775 kids, 850? Any estimate?
I personally would not know that estimate. It also depends on the flow of the oncoming traffic, because this is a roadway that will have some opposing movements from the southbound left in and the northbound right into the school. There are other factors. I do believe, as their transportation engineer said, that they will warrant it before the widening happens. This widening is going to be a little bit slower of a process. So there are some things that might be factors, not just the student population. For instance, if the student, this is very rare, right? But if the student population weren't to grow for a while, that 4-lane widening might accommodate enough of the traffic as is, and it might not be warranted until after the 4-lane widening occurs. But it's very speculative at this time.
Right.
And probably unlikely with the motivation that the school has to serve their population of students.
All right, very good, thank you. All right, and Ms. Marshall's Planning Commission staff here today?
Yes, they should be on virtually.
Okay, Planning Commission staff?
Hi, yes, good morning. Alexis Myers, Planning Commission staff. The subject site is located in the residential 4 future land use category. It is in the urban service area and not located within the limits of any community plan. The proposal satisfies the intent of future land use section objective 4.4 and policy 4.4.1, which require the new development to be compatible with the character and scale of the surrounding neighborhood. The proposed development is consistent with the established context, as it represents a continuation and enhancement of institutional and residential support uses already present in the area. Based upon those considerations, Planning Commission staff finds the proposed special use consistent with the unincorporated Hillsborough County Comprehensive Plan, subject to the proposed restrictions by the Development Services Department.
All right, very good, thank you, ma'am. At this point in time, is there anyone in the audience who wishes to speak in support of the application? Is anyone responding? Anyone in the audience wish to speak in opposition to the application? Is no one responding? Staff, anything further?
Nothing further.
The applicant, an opportunity for rebuttal.
Just make a couple comments, Mr. Hearing Officer. I do want to recognize some of the other board members who are here and attending, because this is obviously a very important request for them. I want to place just a little emphasis again that the student growth is expected to be over a long period of time, and that's substantiated by the complete history of the school. And I think you've heard plenty of information that the school has worked with the county and law enforcement in the past and obviously in the future, and work with Mr. Razor to be sure that what's proposed for transportation does work and does not impact Lithia Pinecrest, particularly with the improvements that will be coming. And with that, I would just say in summary that we're glad to have the support of the zoning staff and the Planning Commission. I also noticed by memory, I believe it's 38 persons a couple times, and we're very happy to hear that there's no one here in opposition. I think that speaks very loudly. And Mr. Razor has some comments. Thank you.
I'd like to address your question regarding when the traffic signal might be warranted. During the course of the preparation of our analysis, we did identify that Public Works had done a warrant analysis within the past year or so. They found that it was not warranted at that time. I looked at their study, And when you look at traffic signal warrants, the one that's most applicable to a school is what's called the peak hour warrant. The county didn't, they looked at other warrants and perhaps not the peak hour warrant in a full fashion. And from my work on this project, we are very, very close to warranting a traffic signal with current plus very, very minor growth to meet those warrant criteria.
Right, so your professional opinion, it's close.
Very, very close, yes.
All right, as far as you know, has the applicant started the process? Because it takes a long time.
It does. And the conditions of approval calling for the warrant analysis to be done at each increment of approval, I would imagine that during the first increment of approval, we would be looking at warranting the signal. Typically, from the warrant study being done to signal being implemented, it's at least a year, sometimes a little bit longer, but that's generally what we'd be looking at.
I mean, it's really not particularly applicable to this special use hearing, but for the applicant and the principal who's sitting there, it can take a year or two to go through the warrant process, ordering all the components of a traffic signal, the posts and the signals. So if your transportation expert is telling you you're close, I would recommend to you, independent of the special use, that you get started on that process. All right. Anything else, Mr. Pressman?
No, we appreciate your time and attention. We appreciate working with the staff.
All right, very good. With that, that concludes this application. And that concludes this morning's land use hearing, officer hearing. We are adjourned.